morning, everyone. It's 9:30, so I'll start the meeting. My name is David Liddell. I'm the reporter appointed by ministers to report to them on the planning appeal by Loch Long Salmon Limited for the proposed fish farm at Beinn, Reithe. First, can everyone hear me okay at the back? Yeah, okay. Well, let me know if you can't. If anyone at any point can't hear what's being said, then please let me know. Also with me today from DPEA is Lucy Wakeham, and Lucy's handling the IT and the webcasting for the meeting. So this is the first of several hearing and inquiry sessions we'll be holding this week and next. The subject matter this morning is the planning policies and other policies relevant to the appeal, and only the appellant and the National Park Authority are participating this morning. We then have a hearing this afternoon with several more parties on the nature of the proposed development. We can take a short break this morning if we need to, and then we'll come back after lunch for the second hearing. So just a few usual housekeeping matters. There's no fire drill planned today. There are 2 fire escapes on either side of you. There's also one behind me. The toilets are in the corridor behind me, and there's a fire escape at the end of that corridor. And if everyone can just put phones and other devices to silent, please, if possible. Okay, the final thing, I suppose, just everyone participating in the room should be aware that the meeting's been webcast and recorded. So by participating, you're agreeing to being recorded and to the use of that information for purposes including staff training and making information available to members of the public. The recording of the meeting will be retained for viewing on our website. And to operate the microphones here in the room, just press once to turn on the button at the bottom, and the red light should come on. Press again to turn it off when you've finished speaking. And it's important that we all use the microphones properly. Important we turn them off when we stop speaking, just to give the clearest recording for the webcast. And if you need to move them around, please do so by the base rather than the stem. And probably don't lift them up while you're speaking. Okay, so that's who I am. I'm going to ask the 2 parties participating to introduce themselves. First, the appellant, Mr. Findlay.
Yes, good morning, sir. My name is James Findlay, King's Counsel. Sitting beside me, I have David Bell, who's going to give planning evidence, and beside him, Patrick Munro, who's unlikely to be speaking, but from Burgess.
Thank you very much. And for the Park Authority, Mr. McKee.
Good morning, sir and everyone. My name is Alistair McKee. I'm a solicitor instructed by the National Park Authority. On my right is Stuart Mearns, who is the Director of Place. On his right is Alison Williamson, who is a planning officer. All of us will be addressing the issues regarding policy in this session 1, sir. Thank you.
Okay, thank you. So I sent round an agenda the week before last, and I added an item to that last week. So I'd like to go through each of those agenda items that I've identified. Otherwise, I think I understand the position of both parties and what the applicable policies are. But if you think there are important issues that I've not put on the agenda that we need to discuss and which arrive from the policy hearing statements, then I'm happy to hear about that too. So if we go through my agenda items first, if there's something you want to say about one of those policies as we're discussing them, then bring them up. But perhaps if there are other policies that I've not covered that you think we can maybe come back to them at the end of my agenda. Does that sound okay?
Sir, it might be wise just to deal with the issue of the sort of late documents at the inception of before we actually turn to the individual policies themselves, sir. Yeah,
I was going to come on to that. We had various documents last week submitted. Some of them weren't controversial in as much as they were submitted by the appellant. The National Park Authority was happy to accept them. There were, as I left it on Friday, there were 3 other documents that we were going to pick up this morning. However, we had an email, Mr. McKee, from you, I think it was Sunday, it might have been Friday night, saying that the National Park Authority was content to accept those last 3 documents, provided we could admit some other documents from the National Park Authority that talk to those matters. Have I got that right? Yes.
That's correct. The substance of that's correct, sir. I didn't send the email, unfortunately, until this morning at about 7 o'clock, but everyone's been copied in. So I apologise for the lateness of that, but they are documents that simply react to documents that have been lodged, so, and I can speak to them in a bit more detail if required.
Okay, Mr Finlay, I don't know if you've had a chance to see that email or to discuss it with Mr McKee.
I've had a chance to see the email, and we make no objection to the documents. There's one of the documents which is entitled Chapter 2, Special Qualities. It would be helpful to know, it's clearly an extract from a larger document, to know which that larger document is, and that can be dealt with in due course, so I think that's unlikely to arise today. So it would be helpful to hear from Mr McKee where that document comes from. And so there is another preliminary issue in that I think we gave notice that one of the questions in the landscape and visual impact session has a policy angle to it. We only have Mr Bell here today, and obviously we don't mind when the park gives their response to it, but it would be, we would welcome the opportunity to have Mr Bell give his view on that today, and that indeed touches on some of the documents that we've both been putting in. Perhaps I can put that down as a point we'd like to cover later, particularly as you've raised it. But as I say, we have no objection to the park coming back to that tomorrow, or dealing with it today and tomorrow.
Thank you, Mr Finlay. I'll come back shortly about the actual provenance of the document and the Chapter 2 to find out what the larger document is. I don't instantly have that information. In regard to the policy, I think we just want to be clear about what we're talking about. I think we're talking about policy NPF 4C. That's my sort of assumption. It's not on the agenda, but that does bear to be the sort of central NPF 4 policy that deals with the objectives of the designation of the park and its overall integrity. So I just want to be clear exactly what we're talking about.
Well, it's the question, sir, that you raised under question 9 of the seascape, landscape and visual impacts. There were 3 parts to that question. It's the first part, which relates to what is the correct test, which is clearly an important issue, and that will be dealt with, I think, primarily by looking at the policy documents, and it may also be that Mr Bell will have something to say whether the national park is a landscape designation, which is the last question under that, so it's both those 2 points, but none of the other points under question 9.
That's understood, sir. Obviously, the National Park has its policy advisors here today, so we can deal with that to a certain degree. But if it's going to go sort of migrate into the complexities of the the special landscape and its character and its assessment, we really need to have Mr Harman here, and he's coming tomorrow. So maybe it's going to be dealt with over 2 days or in 2 sessions.
Okay, that's helpful. I think it may do, Mr McKee. So just to explain, when I was putting those questions for the third hearing, I was thinking about, really in landscape terms, what's the extent of the receptor which any assessment of significance of effect relates to. So it was more about understanding the professional judgment or the expert advice from landscape architects, I think in particular from Mr Harman. And to a certain extent, I think the same also applied to the second question. The question about designation really arose for me because I was interested in how the value to be ascribed to any landscape within the park when making a landscape and visual impact assessment, not when applying a planning policy, is informed by the designation of the park itself. So that's where I was coming from. It was more a technical question, but I can see that there's a policy, or there may be a policy read across. So I think, that sounds sensible, Mr McKee. If there are policy aspects to that we can handle today that we need to then fine. but it's probably also a question for Mr Harman in terms of his methodology. That's where I was coming from, if that makes sense. Okay. Before I move on to my agenda, then, is there anything else procedurally we need to pick up? Okay, excellent. Sorry.
So just to simply say that the Parks documents will be 136, 137 and 138, so they have a number. So.
Okay, so we can maybe get an updated document list just in due course. You might just, for the purpose of this morning, just might have to tell me the title. I've downloaded them onto the computer. Okay. Some of the questions that I have are quite closed ones. That's fine. The answers might not be long to them. So the first one is about the development plan, and section 24 of the Act says that where there's any incompatibility between the terms of the local development plan and the national planning framework, as they apply in this case, that whichever is the latter document prevails. I didn't see any evidence to say that there is any incompatibility that I need to address, but I just wanted to check that with the parties. I'll ask the Planning Authority first on that.
Thank you, sir. The Park Authority were looking at the Chief Planner's letter for some guidance on that, sir, and that's core document 3.15. And the advice given in that letter is that, and that's the interpretation of the word sort of incompatibility. It describes it, are they in contradiction or are they likely to be considered incompatible? And the National Park's view is that that is not the case. These policies are broadly aligned, although the National Park's view is that the National Planning Framework 4 and its incorporation into the development plan strengthens some of these policies and thus strengthens the Park's reasons for refusal.
Okay. Mr Finlay, I don't know if you've got or if the appellant's got a view on that.
Thank you. Yes, I think generally in broad agreement that we also took account of the Chief Planner's letter, did not identify any conflicts or contradictions. What I would say, though, is that insofar as NPF4 now forms part of the development plan, it's clearly the most up-to-date element of the plan. And we have a new aquaculture policy, which we will come on to, which is the up-to-date national planning policy and development plan position. And I think in that regard, not just the policy, but the intent and the outcomes, which are set within the policy principles at the start of that policy, will be important to take into account. And the appellant's position is that that strengthens the position that the appeal should be upheld for the reasons we will come on to. Thank you.
Okay, thank you. So that takes care of item 1. Item 2, related to NPF4 Policy 2, Climate Change and Mitigation, and the National Park Authority's hearing statement points to high energy inputs from the development. And I'd asked, is the authority's view that the proposal does not comply with this policy? Although, looking more closely, I think you've already told me the answer to that. In 3.6.2 of the hearing statement, I think it's clear that the National Park Authority expresses a view that it doesn't comply with that. It's not put in those terms, but I think that's the implication. So I maybe jumped the gun with that question. You probably answered it in the hearing statement.
Yeah, I pass over to Alison Williamson, sir, who deal with that, but I believe you are correct. We do think that this proposal is in conflict with policy NPF 2.
Thank you. Yes, the National Park's view is that the proposal does not comply with this policy. The nature and climate crises are a central focus of National Planning Framework 4, and the policy 2 intent is to encourage development that minimises emissions, and the proposal would not do that. It's not been designed to minimise emissions. It would have a high energy input, including power, fuel, oxygen, pumps, lighting, monitors, basically a 24-hour operation. Traffic volumes, including for personnel, oxygen feed and other deliveries, supplies, materials and salmon taken away for processing, and waste removal. No information was provided by the appellant on emissions and energy requirements for the development. In relation to this, the Chief Planner's letter that's just been referred to, which is core document 3.1.5, recognises that there isn't a sort of accepted methodology for calculating or minimising emissions, but it does go on to say that for development proposals that may generate significant emissions, such as national or major developments, of which this is one, in terms of it being a major development, we consider it to be reasonable to expect quantitative information to be provided. No information was provided by the appellant on this. In addition, the EIA regulations require an EIA report to include an assessment of the impact of a project on climate, for example, the nature and magnitude of greenhouse gas emissions and the vulnerability of the project to climate change. The appellant's EIA scoped out climate change as not requiring further assessment. It was advised that the development was not expected to have a significant effect on climate change. The appellant's arguments for compliance appear to be based on potential benefits that might accrue to the wider industry, i.e. they are aimed at sectoral benefits. NPF4 Policy 2 applies specifically to development proposals. So the assessment under this policy is the development under consideration and not the industry as a whole.
Okay, thank you. I'm going to, obviously, I'll come back to the appellant. I just wanted to follow up on one point about that. I know what you've said about the EIA and the Chief Planner's letter and information requirements, but in terms of the inherent nature of the development, leaving aside transportation effects, the kind of operational energy use you described, it sounds like those will be the same or similar for any fish farm of this type. So it isn't an argument that its high energy use inherently makes it unsustainable. Isn't that an argument for consenting any fish farm of this type in Scotland?
I take your point, but I would say not necessarily, but due to the location chosen for this development proposal, in that there are sort of high transportation requirements in terms of the distance from the main road junction, requiring transport along a rural road, the forestry track, and there's obviously a high, more so than a sort of standard fish farm. And I see what you're saying about this technology would be the same, but in this particular location, our view is that there would be high energy requirements.
If I could just perhaps add, sir, that there is more than a little ambiguity as to what the nature of this proposal is, and I know we're going to be talking about that in the next session, but what the Chief Planner's letter points to is that it is reasonable to expect quantification, and we don't have that quantification. That's what's caused difficulty in the policy assessment of this particular project.
The Chief Planner's letter, was that not after this was determined, or was it before that? I can't remember.
Well, sorry, the Chief Planner's letter post-dates the park's refusal, but obviously NPF4 was not part of the development plan until February of the 13th of this year. So this is information that, has arisen post the decision, but it's still live for the purposes of this hearing, sir, and the Minister's assessment. And the appellants have obviously lodged and founded quite extensively on the Chief Planner's letter. I'm simply quoting back exactly what the Chief Planner is asking for developments such as this, a quantification of the energy and significant emissions used, sir.
Okay, thank you. Anything from the appellant side on this item?
Thanks, sir. Yes. In terms of Ms Williamson saying that the nature and climate crisis is the focus of NPF4, that is correct. But Policy 3 primarily deals with the biodiversity, and we have Policy 1 dealing in particular with the nature crisis and climate as well. In terms of the point about fuel, electricity use and so on, that would be standard across any fish farm development as has been highlighted. In terms of electricity use, there's a commitment to a green tariff, so there can be renewable electricity used to power the development. In terms of a number of the traffic points, we'll come on to that, but the fish coming in and the fish going out would be by short sea shipping. The location is relatively close to the central belt compared to many other fish farms on the west coast of Scotland, particularly in the northwest. And given the nature of the development, it's inevitable that there will be a rural location. We can look at the traffic numbers, and I know that's coming up later on the agenda in terms of the EIA report and what that says, but the numbers were extremely low, below any threshold of significance in the EIA methodology. So to say that the development is acceptable because of high transport requirements and it's a rural road, we think is simply not tenable to justify a reason for refusal on that basis. In terms of the EIA regulations that have been referred to, there was no request for any additional information by the Park Authority on that topic during the determination phase. And if the climate impact was addressed in the EIA report, but was scoped out because it was considered there would not be a significant effect on it. In my hearing statement, in terms of Policy 2, I've drawn upon the strong crossover with NPF4 Policy 1, which deals with climate, and have also there highlighted some of the attributes of the development in that regard, in particular the greenhouse gas emissions from farmed salmon when they are compared against other food production. So the key document in that regard is the government's vision for sustainable aquaculture, which is APP 3.17, that makes it clear that the greenhouse gas emission profile is lower than many other farmed sources of food, and there is data on that also reflected in APP 6.70, which is the research briefing from the SRUC Rural Policy Centre. So the appellant's position is taking all that together. There is not a justification to refuse the development on the basis of climate impact. And in fact, actually, when you look at some aspects of the development, it will have a beneficial effect. Now, the point was made that the application has to be considered on its merits and not on the basis of what other schemes may come forward. That's entirely right. But I would say that if there is a scaling up of the environmental benefits that the project would offer, then that would be a material consideration that could be taken into account. Thank you.
So I'd just add to that there's no reason for refusal relating to this issue, but it does form one of the overarching or elements of overarching Policy 1, a requirement to reduce greenhouse gas emissions, etc. If that had been of a real concern as opposed to a manufactured concern by the park, it would have been raised at the time.
Sir, could I respond to that? It's categorically not a manufactured reason for opposing this proposal, sir. Policy 2 of NPF 4 relates to development proposals. So it is this proposal we're looking at. It's not about sector-wide or industry-wide potential benefits should this be consented and rolled out, sir. And I return to what the Chief Planner's letter states, which is it's reasonable to expect a quantification of these issues. The appeal was made I think in February of this year. The appellants have had plenty of time to quantify those benefits in the many documents that have gone back and forth, including, of course, their hearing statement and subsequent statement on policy.
I was going to ask you about that point arising from the Chief Planner's letter. I think it's perhaps on the agenda, I think, for this afternoon about energy emissions, but is that something that we can talk to this afternoon then?
Yes, no, we'll have Mr. Shotter will be giving evidence about answering your question on that point this afternoon.
Okay, that's probably enough for me on this policy. And I'm happy to move on if you both are. Okay, so another closed question this time for the appellant. NPF Policy 3, Biodiversity. I think parts B and C of it are disapplied for aquaculture by another policy in NPF 4, but part A isn't, at least not expressly. So I just wanted to clarify, is it accepted that part A of that policy is engaged for ministers when they're determining the appeal?
Yes, sir, we would agree with that, but just some caveats around it. You're quite right. It's not caught by the express exemptions, but I would say NPF 4 we need to read as a whole. That's clear in all the guidance and in the document itself. And I think if the exemptions of a particular purpose, which they do, which exempts from the need for biodiversity enhancement, then it would be odd if one needs to then bring it in through Part A. So in that regard, it should only be afforded limited weight, we would say, although it is technically engaged.
So sorry to interrupt. Do you think it's odd that it wasn't also disapplied to A expressly then?
I think so. And then the point I was going to make is that, nevertheless, it's important to recognise that the nature of this particular development compares favourably to the open pen approach. I don't intend to go into in any detail the environmental benefits, but there's a helpful summary in the Statement of Appeal, Table 1, page 4, that lists those. So, notwithstanding the requirement for significant biodiversity enhancement is not there, there would be a number of, we say, biodiversity benefits that would nevertheless arise. Thank you.
Okay, I'm just going to close that door. I should have done it earlier. Okay, thank you, Mr. Bell. Has the National Park Authority got a view on this item?
Yeah, I can just add to that, please. Our view is that Part A is engaged and that the development is required to contribute to the enhancement of biodiversity, including, where relevant, restoring degraded habitats and building and strengthening nature networks and the connections between them. Policy 3A also states that proposals should integrate nature-based solutions where possible. It's closely aligned with the National Park Local Development Plan Natural Environment Policy 6 on enhancing biodiversity. And we would also point out that Policy 3D of NPF 4 is also in play and is not disapplied by Policy 32 either. This requires that any potential adverse impacts, including cumulative impacts of development proposals on biodiversity, nature networks and the natural environment, will be minimised through careful planning and design, which will take into account the need to reverse biodiversity loss, safeguard the ecosystem services that the natural environment provides, and build resilience by enhancing nature networks and maximising the potential for restoration. The appellant's case seems to be based on the Chief Planner's letter, and their argument is that it's premature to apply the policy as there's no metric or accepted basis of quantification. They also assert that the compensatory tree planting would be a biodiversity enhancement, and the National Park does not agree with this. Our reading of NPF 4 Policy 3 is that proactivity is required in terms of enhancement. And even since prior to the adoption of NPF 4, the National Park's been working with developers and applicants to agree on biodiversity enhancement, regardless of there not being formal guidance in place. There's plenty of examples of ways in which enhancement could be incorporated into a development, including landscaping plans, native hedging, native vegetated areas, suitable plants, drainage areas utilising sustainable urban drainage. There could also be opportunities off-site for biodiversity enhancement. We've also lodged MPA document 135, which is a Scottish Government consultation on tackling the nature emergency, which demonstrates that this issue is of first importance. In Chapter 7, it consults on strengthening the Sanford Principle to include nature restoration and tackling climate change. So, in conclusion, the proposal would not enhance biodiversity and would adversely impact biodiversity through impacts on the Endrick Water SAC.
Okay, thank you. And just on the question, I think I understand the position, or your position, on the question of the replacement planting not being enough, or is that in principle because it's replacement of what was existing planting, or is it based on a more detailed analysis of the biodiversity gains from the planting? Why doesn't that go far enough, I suppose is the question.
In principle, of the terms of that's a replacement for trees that have already been felled, which we haven't been able to really quantify any of that, but yeah, in principle that's not an enhancement, that's just compensating for a loss.
Thank you. We've set out the appellant's position in terms of the exemptions, and there's a particular reason for those exemptions because of the nature of the development. My understanding is that Policy 6, in terms of biodiversity, wasn't a reason for refusal, so there had been no concern by the Planning Authority during the determination phase on that. In terms of paragraph D of the policy, the appellant's position is that there has been careful planning and design, and that will come through in Mr Flannery's evidence to come. In terms of the compensatory tree planting, my understanding is that that would be enhanced planting with semi-native species. So that's a factual matter. It's not simply replacement with commercial forestry. So to say that there would be no enhancement there is wrong. Furthermore, that would be addressed by way of a condition which the NPA would be party to. So the Park Authority will have an opportunity to consider that and sign that off effectively in due course. I think the other points I've covered when I spoke earlier. Thank you.
Sir, if I could maybe just briefly respond. This particular policy in local development plan terms is not a reason for refusal. But this is not a hearing and inquiry into solely the park's reasons for refusal, sir. It's about what is the development plan, and the development plan focused upon this is the most recent sort of version of the local plan is the NPF Policy 3, which states development proposals will contribute to the enhancement of biodiversity, then goes on to explain such. So this policy is engaged whether it's within the reasons for refusal or not. And certainly the Park's view is that a lot more could have been offered and couldn't be done if this were to be consented to fulfil the aims of that policy, which are quite clearly enhancement of biodiversity.
Okay. Yep.
Briefly on that, Mr. McKee, I'm afraid, makes a very bad point. Natural Environment Policy 6 says development will be required to enhance biodiversity, which is almost identical to the language in NPF 4 Policy 3. So if it's another example of a manufactured stance by the Park, I'm afraid.
So that's not accepted.
Okay, I was already writing that down before you said it. Okay, thanks. I think that's enough if you're content on biodiversity. NPF 4 Policy 3.
So just before we leave there, let's not forget Policy 3D as well, sir, which states that any potential adverse impacts need to be minimised through careful planning and design. That isn't a policy which was part of the development plan, but is quite clearly in play in this particular appeal, sir.
Yeah, no, noted. And I simply didn't ask for it because I was more interested in it was about the interpretation of it rather than the application, if you like. Okay, so if we move on to item 4, which is NPF 4 Policy 4. So I'm just going to look at that. So yes, Part F, development proposals that are likely to have an adverse effect on species protected by legislation will only be supported where the proposal meets the relevant statutory tests. So the reason I'm asking about this is normally when I've seen that policy being applicable, it tends, the implication is that a species licence it might be required by Nature Scot, and that's what the relevant statutory test tends to rely on. Maybe I've got that wrong. I'm not aware that there's any suggestion that Nature Scot would have to issue a protected species licence for this development, but maybe that's just because it's not been discussed. So that's why I was interested in the question of the relevance of this policy and the same thing from Natural Environment Policy 4 of the LDP. So there's possibly two questions. Is this part engaged? And would there be any, does the National Park Authority think there would be a need for a protected species licence, or has that even been considered?
Our interpretation of the policy was that this more related to the habitat regulations rather than a protected species licence.
So if I can maybe just come in there, I think it's open to interpretation as to whether this is discussing any particular statutory test, of which Regulation 48 of the Habitats Regulation is but one. I agree with you that it could also be interpreted in regard to protected species licensing and the need for licences to support development proposals, but it's rather open to interpretation. But so I think we're agreeing with you, but we also think it could also encompass appropriate assessment as an example.
Okay, but from the I haven't seen anything in the evidence that suggests a species licence might be required. So maybe I'm off at an unnecessary tangent here in thinking about it.
So I'm not aware there's any reference in the case to the need for protected species licences for this proposal. Okay, so that's taking more to thinking about that policy, at least in this case, about the habitat regulations. So the appellant got a view on that point.
Sorry, yes, I'm just going to say that the EIA report, chapter 10, may be helpful, terrestrial and coastal ecology. It sets out the protected species that were incorporated into the assessment, but there were no significant effects predicted. And planning conditions have been agreed with the Park Authority relating to pre-construction surveys for certain species, and there would be a pre-construction survey undertaken which would be fairly standard, which would catch anything should it arise at a later post-EIA stage.
Okay. I mean, I may have got this wrong, but I think in the National Park Authority's evidence there was a reference to Atlantic salmon being a protected species, and that's why I possibly came down this wormhole.
That is correct, sir, yes. They are a protected species when they're in rivers, I think. I think that's the way it works, sir.
But you're not going so far as to say that that means the licensing tests apply to this case?
So the National Parks case is that this fails an appropriate assessment. It has significant adverse effects on the integrity of the SAC. That really the beginning and ending of its opposition to this proposal in terms of this part of the evidence, I feel. So before are you moving away from policy 4 now? Because I was just wanting to be sure about that. Because we do have policy 4C, which is set in 2 parts. As you'll be aware, sir, the National Park, in their hearing statement, I think it's paragraph 3.6.19, have indicated that this proposal is contrary to policy 4C. The documents which were lodged on Thursday and now this morning by the Park Authority obviously bear upon the interpretation of that particular policy. So I'm not suggesting we necessarily deal with it right now, but I'm just wanting to be sure that we are going to deal with that. I think it would be advisable, at least in a policy sense, and then we can deal with it tomorrow in a sort of evidential sense from landscape impact assessment, seascape.
Okay. If it's fine for you both, I think I'd rather come back to that at the end because it might be a more wide-ranging discussion than
That's fine, sir. That's fine. I just don't want to lose sight of it, sir.
Okay, yeah. So remind me if I forget. I'm sure I won't. Okay. Before we move on, is there anything else from the appellant on that point? Okay, it's another question about interpretation of policy now. So item 5 was about NPF 4, policy 10 on coastal development. Right, let me just find. If you give me bear with me a minute, I just want to find the passage I wanted to ask you about. Is it B? Yeah, B1. Yes, so development proposals in undeveloped coastal areas will only be supported where they are necessary to support the blue economy, net zero emissions, or to contribute to the economy or well-being of communities whose livelihood depend on marine or coastal activities, or is for essential infrastructure, where there is a specific locational need and no other suitable site. At comma, I wonder whether it really should be there or not, and whether that qualification about a specific locational need and no other suitable site, it makes more sense to me that that's only relevant to the essential infrastructure provision, not to those earlier parts of B1. So I just wondered what other people's interpretation was of that. I'll ask the appellant first on that.
Yes, that is my interpretation of that. Otherwise, there would be a sequential assessment required for any coastal development on the other aspects. I think it's split into 2 parts with or, and that locational need relates to essential infrastructure, I would say.
Okay, thank you. Has the National Park Authority got a view on that question?
Our view is that it's not particularly clear. However, we note that the appellant references that the proposal supports the blue economy and there is a locational need for the development. So they seem to have accepted that specific locational need applies to the proposal. The National Park view is that the proposal doesn't actually meet any of the criteria listed in the policy. It would not be necessary to support the blue economy. It may be desirable in the appellant's terms, but it's not necessary. The fish farm proposal does not lead to net zero emissions, although it may provide some benefits to the local economy. It's not essential infrastructure, and there is no specific locational need for the site. So in our view, the policy is contrary to Policy 10, regardless of how it's interpreted.
Okay, so that idea of being necessary to support the blue economy, in your view, you're taking necessary, but that's setting quite a high bar. That really means necessary, not just it would contribute to the blue economy. Okay. Okay. Have you got anything to add from that, from the appellant side, or do you want to just move on?
Yeah, we can move on. There may be some other some aspects of this point that we come to in some other policies to come.
Yeah, but it does sound like an in-principle objection to fish farms. If that test is being set that high, it'd be difficult to envisage any fish farm surviving that test.
Can I just comment that this policy specifically relates to the undeveloped coast? So that's where we're coming from.
What about that? And I'm not asking you to answer a hypothetical question if you don't want to, but the proposition then would be that that policy would rule out, well, on Mr Finley's wording, it would be difficult for any fish farm to survive that policy in the undeveloped coast. Would you agree with that, or are you not going that far?
We don't have an in-principle objection to fish farms.
I would add, sir, that just reading NPF4 sort of in the round and more generally, it's raising the bar across all of these policies, and maybe this is just one particular example where the bar is being raised. It's going to make it very difficult for fish farming to be approved under Policy 10, sir, but that may well be what the Ministers intend.
Is there one brief point just on what NPF4's position is? It's just, when I first started speaking, I referred to the policy intent. And in terms of policy 32, that is to planning should support the aquaculture industry, ensure it's diverse and competitive and reflect industry needs. New aquaculture development is in locations that reflect industry needs and considers environmental impacts. So we've covered the biodiversity points, and that's fully accepted. But it is an encouragement, a promotion, a facilitative policy. It's not a restrictive one. So what was said about policy 10, if that really strict interpretation was applied, it would cut across policy 32. And that's why I would return again to the Chief Planner's advice about reading NPF4 as a whole. I think that is so important. Thank you.
Okay, yes, and it's a question of weight, isn't it? I think either the Chief Planner's letter or in NPF4 itself, it says that it has to be read as a whole, and that some policy objectives conflict with other policy objectives. It's going to be a case-specific assessment. Okay, if we move on to item 6 then, it's another dry question. It's about policy 29 of NPF4. So yes, so policy 29A, development proposals that contribute to the viability, sustainability and diversity of rural communities and the local rural community will be supported, including, and then it lists 10 types of development that would be supported. And the appellant's evidence says that list is non-exhaustive is the phrase used, meaning, I guess, that including means that there might be other things not listed. And I just wanted to check whether the National Park Authority accepts that interpretation.
Yes, we would accept that interpretation that the list provided is not exhaustive. Even though aquaculture is not listed, it's widely recognised as a rural development, and this policy is therefore relevant.
Okay, I'm not sure there's anything to come back on in that.
Very fair position. Just one point I wanted to add, which links partly to what we just previously discussed, was in NPF4, page 22. It refers to the regional spatial priorities for this part of Scotland on the west coast, and it sets out priorities on page 23, and there are only 3 priorities for this part of Scotland listed. One of them is seize opportunities. This is the 3rd bullet. Seize opportunities to grow the blue and green economy, recognising the world-class environmental assets that require careful management. Clearly, I would say the National Park falls into that environmental asset category, but it's clear what the government's saying is that, look, there's opportunities here. That links to Policy 32 as well in terms of facilitating that growth in appropriate locations. Thank you.
These are quite, across NPF4, quite generalised priorities, aren't there? I mean, there's again that question of balancing that generalised priority with the much more specific policy direction, if you like, which comes afterwards.
I think that's where that would come in, where inevitably there will be some policies that pull in different directions. So that's in any planning case I've been involved in, that's the case. But when one looks at the overall objectives of the development plan, not just the individual policies, that's when you get the flavour of, where the weight should be going. And I think that is hopefully of some assistance when you see what the direction is for those aspects of the economy and the environment on the West Coast.
So just to come back a little bit, I agree to some extent with what Mr. Bell is saying, but remember this proposal is in the National Park, and the National Park is afforded particular protection within many parts of the National Planning Framework. So.
Okay, and we may come on to that point, Mr. McKee. That's probably that we've already covered. But so, Mr. Bell, just so I understand what you were saying there, is that in any particular part of the country, those priorities will help you interpret the detailed policies in the best way. Is that, without putting words in your mouth, is that what you're saying?
I would add to that, help interpret and apply weight Yeah.
Yeah, I think that's what I mean.
And in terms of the national park, I think, to be fair to Mr. Bell, he expressly recognised the point Mr. McKee actually made by saying that the world-class environmental assets would include the park. So there's no dispute between the parties on that.
Okay, thank you. So if we move on then to MPF 4 Policy 13, so this is item 7 in the agenda, sustainable transport, and we touched upon this already, I think, in one of the earlier answers, but in its response to the appeal, the National Park Authority says that the National Park Authority accepts the requirement for the proposal to be in a remote rural location. However, the location is not considered to be sustainable. And so I was just wondering if you could expand upon this. What is it about the proposed remote rural location which makes it unsustainable? And I suppose the flip side of that, well, what kind of remote rural location might qualify as being sustainable?
The National Park's view is that the location is not sustainable for a number of reasons. It's not a location which supports sustainable travel, which is one of the policy outcomes of Policy 13. It would require travel mainly by road. As we've already discussed, the numbers of staff, HGV, delivery and servicing trips. The distance of the site from the main road is 4.8 kilometres from the access junction with the A83. Road upgrades, passing places and a new section of road would be required. The definition of sustainable travel in MPF 4 includes travel by walking, wheeling, cycling and public transport, all of which don't seem to apply to this development. The definition does go on to say that in rural areas, low emissions vehicles and shared transport options will play an important role. And we do recognise that the EIA report states that staff will be encouraged to share and car share, and that the appellant is agreeable to electric vehicle charging points. However, I'm not sure that this goes far enough to make the development sustainable. In terms of locations which may qualify as being sustainable in the rural areas, would be areas with existing infrastructure such as a jetty or close to a main road or railway, or a proposal with lower transportation requirements, something that would use existing infrastructure and would be more accessible.
Okay, thank you. The appellant got anything to say on this point?
Thanks, sir. Yes. The transport is addressed in Chapter 15 of the EIA report, and for your note, there is a table, 15.10, which sets out the predicted traffic generation, which is a 1.3% increase over the baseline. The minimum threshold for impact of traffic generation at sensitive receptors in methodology is 10%. So there is no way, in my view, that the traffic generation in the trips that are predicted would be at a level of significance, and the conclusion in the EIA report is that it's a negligible magnitude of change in terms of that construction phase. Similarly, in the operational stage, it's minimal and negligible in terms of the figures, and that's, for your note, paragraph 15.3.3.2 of the EIA report. I think in terms of cycling, walking, public transport, if this was a retail development or something similar to that, more conventional urban development, I think these would be much more relevant. 4.8 kilometres to the main road, in my view, is not that far. And in terms of putting the development close to the road, the likelihood in that case would be that there would be a much greater visual impact. So I think there are a number of trade-offs with some of these points that are being made. In terms of low-emission vehicles, the appellant is agreeable to EV charging, car sharing, so the small number of trips that are predicted may well be less because of that. And the EV charging, I understand, is a matter of a planning condition. So for these reasons, the appellant's position is that it wouldn't be justifiable to refuse the development on the basis of it not being a sustainable location for the reasons set out. Thank you.
Okay, thank you. I mean, I've read the EIA report, including Chapter 15. I'll check again. We can go there if you want, but just so as I got that right. Table 1510, 1.3% over baseline. That's construction phase. That figure relates to, not operational phase. It's not assessed as operationally because it's negligible. Okay, and that 10% threshold for assessment. I'll check, but isn't that more about the effects of extra traffic on a receptor at the side of the road rather than a climate change or a sustainability threshold for assessment?
To give a calibration, if you like, of the trip generating characteristics of this development, that it's negligible in that regard, but also not significant in terms of that wider point you're making in terms of general traffic use.
Add to that, there is a general policy in the local plan, overarching policy 1, which requires developments to contribute to sustainable development. It's the second bullet point. But that wasn't even considered relevant in the report, the Parks report. If you look at 8.7.3, picked out 3 aspects of overarching policy 1 that were relevant, and that wasn't one of them. So again, it would appear to be a matter that is raised. And you,
sir, if I may respond, we don't, in terms of obviously NPF4 is the focus of what we're talking about right now on the agenda, and so that is the assessment, and our statement and our evidence has focused on that. Clearly, as has been noted, NPF4 is setting out a step change in terms of tackling climate and nature. So when we look at sustainable transport and sustainability of the proposal, then that's where our position is bedded in. But the key point being, in terms of it does relate to the locational justification for the site and the site choice. But the point, as my colleague has made on the location, is that it's not using existing infrastructure, and it's clear from NPF4 that's the direction. That's what it's directing, to maximise existing infrastructure and facilities to minimise the travel. And so, given that across in essence the west coast, we have towns and villages which have jetties and otherwise and facilities that are already there. And the whole point, we should be encouraging and promoting the facilities, facilitate development, which really supports use of these facilities as well as travel. So I think there's an important point within NPF4 we must focus in on.
Okay, thank you. Can I ask about the second part of this? The latter parts of the policy refers to development which will generate significant increase in person trips and significant travel generating uses, and there are certain assessments to be made if your development is one of those types. They're not defined, I don't think, in NPF4, so I just wondered, are we agreed that this isn't one of those types of development? ask the National Park Authority first.
Our view is that Part F of Policy 13 applies. This states that development proposals for significant travel generating uses or smaller scale developments where it's important to monitor travel patterns resulting from the development will only be supported if they're accompanied by a travel plan with supporting planning conditions and obligations. The National Park view is that the proposal would generate an increase in person trips, which in this rural location and in this context could be considered significant. It's not considered to be a significant travel generating use. However, we are concerned about the levels of traffic and transport required in such a rural location.
Okay, that's it.
So I can maybe just come back on one point. I mean, I can understand perhaps where the appellants are coming from here, but my clear understanding is that this is a step change policy, and what is particular about this development is not only is the actual route to the public road 4.8 kilometres, but the appellants are having to build a road to get there, so they're actually building a road and then they're going to use it. That's one of the key differences I'd like you to note.
Okay, so there's two things. So I just want to be clear. It's that or smaller scale developments where it's important to monitor travel patterns resulting from the development. That's the relevant part of F. And on that question, I suppose this is just a factual question. The main road is 4.8 kilometres. Isn't the road in a public road for part of the way, or is that? I don't know if I've got that evidence or not, to be honest with you. But if we're focusing on the distance to the public road rather than the main road, I thought the track in was at least for some of the way a public road, but I might be wrong about that.
I think it might be for part of the distance, but it provides access to a number of residential properties, but then it becomes a forestry access.
So we could maybe look into the status of the road and come back to you on that point, sir.
I mean, it's not a big. It's just to be interested in the factual position. Mr. Bell, you want to come back?
Just a couple of points. So it would seem then there's agreement that it's not a significant travel generating use. The concern with the Park Authority seems to be that it's a small scale development where it's necessary to monitor travel patterns. I don't think there's any proposal from the Park Authority to monitor travel patterns once the application, if the development is approved and constructed, or there would be any proper planning justification for that based on any evidence. The appellant is not building a new road. There is an existing track that will be upgraded, so that's factually incorrect. There will be an increase in person trips, but the EIA report shows that will be very small numbers. Thank you.
So, before we finish up, if I could ask the Park through you why they suggest it's important in this instance to monitor travel patterns, because I've understood that's their position, but I haven't heard why they think it's necessary to do so.
I would just comment that we have a fundamental concern about the levels of traffic in this rural area and the impacts. The EIA chapter on traffic and transportation doesn't consider operational effects. It only considers traffic during construction, so we don't have information on exactly the level of traffic during operation, so we have a concern about that.
I note that, but first of all, if it's a fundamental concern, one would have expected to have seen it raised in a report to committee. And secondly, there is an assessment of operational traffic in the EIA. It's paragraph 15.3.3.2. So, with respect, it's a point I've made before, but it's a point the park are making which doesn't have any substance to it.
Sir, if I can just kind of comment on that. Certainly this is transport is a concern, and from memory this was certainly was referenced within our board report, which we can clarify. But the thing is the inherent nature of the proposal and the amount of movements from vehicle movements, from staffing, from the moving of other kind of goods and services, the nature of it being the amount of journeys there. So that was where that kind of came from in terms of materials. So just to kind of expand on that.
Okay, I mean, I can check what the National Park, what the report said to committee. It doesn't. I'm not sure it matters to me that much. I need to reach my own view on what on this kind of the application of the policy. Okay, can we move on then to item 8 in the agenda? Are we both content to do that? That's this question of the National Park Authority. This is the LDP, Natural Environment Policy 11, protecting the water environment, and it refers to, I'll quote, the landscape values of water bodies. So I'm just trying to understand what that means for me or for ministers in the appeal. So are these landscape values of the water bodies of the park defined or described somewhere, or am I over-interpreting landscape values? Does it mean does it maybe mean something slightly different from that?
The simple answer is yes. The landscape values of water bodies in the national park are defined and described in the special landscape qualities of Loch Lomond and Trossachs National Park. That's MPA document 70. That's the Nature Scott document, as well as the Firth of Clyde landscape seascape assessment. The overarching special landscape qualities of the national park, as defined by Nature Scott, include water in its many forms, being rarely absent from the view. It goes on to say there occur deep indented sea lochs, long inland lochs, some straight, some sinuous, lochans, rivers, burns, waterfalls and rapids, a lowland lake, and also wetlands, marshes and mires of many sizes and types. This great variety, in combination with the range of landscape settings, results in a diverse and beautiful landscape. The key characteristics of the steep ridges and hills landscape character type, as defined by Nature Scott, include steep-sided hills with pronounced summits which rise dramatically from narrow sea lochs and deep glens. Some hills form key landmark features in views along the sea lochs. Settlement largely absent even from the narrow rocky coastal edges along the sea lochs, and some parts feel relatively remote, and a richly scenic fjord-like seascape. The key characteristics of the Shepherd's Point to Coilescen coastal character area, as defined by the Firth of Clyde landscape seascape assessment, are that the loch is nearly 15 miles long, becoming ever more enclosed and steeper sided as it reaches back into the rugged mountains of eastern Argyll towards Arrocha. The western shores of Loch Long from Strome Point to the head of the loch and Arrocha lie within Loch Lomond and the Trossachs National Park. The loch therefore forms a marine gateway to the park. There are no existing fish farms on the loch, and there are steep forested slopes which rise directly from the coast, which accentuate the narrowness of this stretch of loch, which creates some drama and is especially accentuated travelling north to the head of the loch.
Okay, well, I think that's helpful. So, if I'm thinking about that policy, I'm going to the special landscape qualities. I'm going to the Firth of Clyde seascape and landscape assessment. I've got that name right. But particularly Loch Long coastal character area of that. It's not landscape values. Where am I? Landscape values of water bodies is not a term of art. There's not a particular thing that's been done. It's taking me back to those more generic descriptions, if you like, not generic in a pejorative sense. Okay, that's fine. That helps me out.
I'll just make one observation so that it may help. Water environment in the context of the local development plan is defined in the glossary at page 120, sir. but it says the water environment is all inland surface water, groundwater and wetlands, as well as coastal waters. So there can be no doubt that Loch Long is captured in the meaning of that policy.
Thank you. Just the starting point, of course, the water where the pens would be is not in the park. That's established. The document that was referred to is agreed. The Nature Scotland or SNH document, as it was of 2010, and Mr. Flannery and the landscape evidence will cover that. The quote is correct as well, but Ms. Williamson stopped the quote at one point, didn't read the last sentence of the paragraph, which results in a diverse and beautiful landscape. It says, as well as Loch Lomond itself, other well-known lochs are Loch Katrine, Erne, Foyle and the Lake of Menteith. Loch Long is not listed in that quote, just an observation. Thank you. That was all I just wanted to add there.
Okay. That's fine. I mean, it was just it was a question of interpretation that was interesting. Items 9, 10 and 11 in the agenda were about legislation. Maybe if we go to 12 first, which is about MPF policy, MPF 4 policy 32 and aquaculture, and I suppose you've just touched on one aspect of that there, Mr. Bell. So, I mean, I think I understand how it works. The Loch Long is not within the boundaries of the national park itself, but maybe that's wrong. But certainly, as far as I understand it, for the part of the loch where the coast is within the national park is the planning authority when it comes to aquaculture development, and it'll be the planning authorities where that's not the case. So, in the Holy Loch, for example, the east side it would be the national park, and on the west side it would be Argyll Butte Council. That's fine. So, in terms of policy 32 and marine aquaculture, the only parts of the park which it could possibly apply to are the west side of Loch Long, and then at the head of the loch, either side, Loch Goyle, and the east or north side of the Holy Loch. Those are the only locations where, by definition, marine aquaculture could take place under policy 32. That's why I'm asking. I just want to understand if this is the wrong place for this development, or maybe for aquaculture. I'm just trying to understand what is the extent of the national park, whether there is any scope for aquaculture development under policy 32. If I'm explaining myself. But have I got that right? That's the extent of the marine park of the national park where anyone could possibly be able to develop marine aquaculture.
So I could maybe just sort of follow on that within that marine planning zone, which is within the sort of the remit of the National Park Authority, it has both development management function and a development planning function. So this local development plan does apply to development within the marine planning zone. Just to sort of square the circle there, so you know about that. And we know about that quite clearly because the aquaculture policy has been promoted and it is intended to apply, obviously, to the marine planning zone.
Could I just add to that aquaculture is not just marine, so we do have some, obviously, other lochs within the park, and we do have a freshwater fish farm in Loch Earn and a land-based fish farm just outside trout farm, just outside Callander. So my view is that the aquaculture policy would apply to those as well, not just to the marine planning zone.
So that's what we were going to say as well, that policy 32 doesn't have a geographical restriction, because there could be trout farm in a Loch Lomond, or maybe not Loch Lomond, but one of those other lochs. So it would apply to that circumstance.
It may just assist that to make it clear, I agree with Mr. McKee that in the marine zone, as he calls it, which is I think a helpful expression, whilst it's not technically within the park, and it isn't within the park, it is an area for which the park has a function in both development control and in putting forward planning policies for. So it is clearly within its planning regime, although it's not technically within the park itself. So I think your understanding at the start of question 32 question 12 is entirely correct. But as I think Mr. McKee was at pains to stress, and we would agree with that, the park has the planning functions for those relevant parts of the various lochs that you outlined.
Thank you, Mr. Finlay. I always become concerned when Mr. Finlay agrees with me, you know.
Sir, if I could just add, obviously, with boundaries and planning authorities and local authorities, this isn't unusual. Just to be clear. Yeah.
Yeah, I mean, I just was making sure that I was not labouring under some misunderstanding. Okay, maybe if we go back to 9, 10 and 11, they might not be long points, although I think we've got some new documents relevant to agenda item 10, and then maybe at that point we can see whether you want to take a short break, depending on how much other business you want to raise. It'd be good if we can finish by 12 or not long after. It just shows there's time for us to reset the room for the hearing at 1 o'clock, but we've got plenty of time just now. So, item 9 was about the National Parks Scotland Act 2000, and again, and the Sandford Principle, and so that, my understanding is, Section 1 of the Act makes that a statutory duty for the National Park Authority. Don't think it makes it a statutory duty for ministers, but I'm going no further than that. It's still applied by overarching policy 1 of the LDP, so it would still be a material consideration, no doubt an important one. Have I got that right?
It would be a little bit more than that. Your understanding is something we agree with, but obviously, curiously, Section 1 doesn't appear to apply to the ministers, but it definitely applies to the National Park Authority, and it was obviously engaging the Sandford Principle in its decision to refuse this proposal. You're correct that the Sandford Principle in its entirety is captured in overarching policy 1, so it becomes more than just a material consideration for the ministers. It's actually part of the development plan, sir. So there'll be it will have development plan status. So that's probably all I need to say about that, sir.
No, you're quite right. I was thinking of it because it's also in the National Park Partnership Plan, isn't it? So, but yeah, it's also in the LDP. Yeah. Thank you. Anything else?
No, not on that. I mean, we obviously dispute whether it would be relevant, but there's a dispute between the parties on that. We don't think the Sandford Principle would be engaged, but that's another matter. But yes, in terms of, I'm afraid Mr. McKee's going to be surprised again. I agree with him.
Sir, if I can just add a point, I suppose this is really key in terms of, obviously, the National Parks Act, it means that, for Loch Lomond and Trossachs, the planning system works differently because we've got the duties set out in the National Parks Act and the aims that apply. So I think it's just, as I'm sure you're already aware, it does distinguish the National Park area as being different in terms of, obviously, there is one other national park, and there may well be others in years to come. But in terms of how the planning system operates, we've got these additional duties under national parks legislation. So I just wanted to make that point to draw to your attention.
Yeah, no, that's noted. Okay, so item 10 then was about the Marine Scotland Act 2010, and section 15. 1, I had from my reading of the Act, assumed that that would apply here to the Minister's determination of the appeal. I may or may not have got that right. I think the appellant was going to. I think the new documents you had submitted speak to that issue.
Yes, yes, it does apply to ministers, and the reason we put forward the Open Seas case is that it's a recent decision which builds on a decision in England which says that the terms of Section 15.1 are broadly those that planners are used to dealing with under the Town and Country Planning Act, whether in Scotland or England. You take decisions in accordance with a marine plan unless, here it says, relevant considerations indicate otherwise. In planning documents, unless material considerations indicate otherwise. But frankly, there's no difference between the two. So it was just to make that point and give you that confidence that there's no difference in approach. It's an approach that planners will be familiar with.
Okay, is there anything to come back on from the National Park Authority's point of view?
Yeah, so I'm broadly in agreement with that. I think the sort of the difficulty of the statute is that it refers to these duties being placed upon a public authority, and then one would hope that you look for the definition of what a public authority is, and you find the word the Scottish ministers, but that does not appear to leap off the page, I have to say, and it may be for various constitutional reasons as to why that's being used, but I do agree that the case which my friend has lodged does support the proposition that Section 15.1 does apply, and I think it does apply. It is applied when the ministers are consenting things like offshore wind farms as well, sir. So I think it does.
So, in this case, I have the Planning Act, which requires me to determine this, which requires ministers to determine this in accordance with the development plan unless material considerations otherwise. And I have the Marine Act, which says, well, it applies a similar test, but the primary test presumably is the one in the Planning Act rather than there's a slight dissonance between those two regimes and applying them both at the same time, is there not?
Yeah, difficult to say. They're both statutory requirements. I think it'd be very difficult to grade them in order of priority. One requires you to give precedence to the development plan. The other one requires you to give precedence to the marine plan. One would hope that they weren't in conflict, but I think if you did find there was conflict between the two, which I don't think either party suggested in this case, it's the interpretation of them, then that would be a relevant or a material consideration that would indicate otherwise. So they're not strict duties. There's a caveat at the end of them, and I think that would suggest that would cope with any dissonance between them. But I don't believe either party considers there is dissonance between the marine plan and the local development plan. And indeed, I mean, I just refer to the answer that was given as to the landscape, to the water bodies qualities. There was reference both to the special qualities of the park, but also the Clyde. Can't remember the full terminology of it now, but the Clyde study, seascape assessment.
Okay, that's not.
So that all having been said, I think the Park's view is that this is primarily a planning decision. It's not primarily a decision under the Marine Act 2010. I accept that the tests are similar, but the actual policies are not. They're not identical. The National Marine Plan is not the same as the National Planning Framework. It is not the same as the Local Development Plan. So there is going to be some, I think, a need to actually look at these in some detail and unfortunately compare and contrast. But we may be doing that to some extent anyway.
Okay, that's fine. And on the final question then I had was about the Nature Conservation Scotland Act 2004 and the general biodiversity duty in section 1. Not a strict duty, I think maybe applies to that as well. Is that agreed that's applicable in its terms? I think I can't remember what it says, but there is a slight caveat in it, or there's a
it says so far as inconsistent with the proper exercise of its functions. Yes, it's a target. So it's a target duty, and there are many target duties. So yes, it does apply to ministers, but it's a target duty akin with many others.
I would only observe, sir, that in the definition of to whom Section 15 of the Marine Act applies, it uses the expression public authority, yet in this particular act it uses the word public body. So we do have a slight distinction in terminology. But public body or office holder is stated to include a statutory undertaker and any person exercising functions of a public nature, which must be extremely wide, sir, and I think they're wide enough to encompass the ministers.
Okay, thank you very much, everyone. That's all the questions I wanted to ask. So, to a certain extent, I'll be guided by you. Is there other ground that you both want to cover arising from the hearing statements? I made a long list of policies where I had no questions, and that's just because I think I understand where both sides are, well, all sides are coming from in terms of their evidence. But I don't want to cut you off if there's other things we need to say. There was obviously the point about the national park as a designation and how that played into policy. But was there anything else that people wanted to raise from the National Park Authority first?
Sir, I did at the very beginning mention National Planning Policy Framework 4C and the policy test in there, sir, which the National Park have stated in their hearing statement for this that this proposal conflicts with. So, and I think it's centrally important. It will be touched upon much more heavily tomorrow, but it may be worthwhile at least just exploring that to a degree after a short break, sir.
Okay. Is that the only thing you want to come back on?
I mean, we can deal with the sort of the landscape designation and the status of the park if you'd like afterwards as well. So, you know, we might be looking at that tomorrow, but we're content to at least discuss it.
Okay, thank you. And from the appellants?
Well, so I think, so far as I understand Mr. McKee's point, it's the same one that we wanted to raise under question 9 of your questions on the special landscape qualities of the national park. So I think there's certainly a coincidence of subject matter there. I would be content to, I think that's a reasonably short point to deal with that now and then have a longer break to set up and prepare for this afternoon. But I'm in your hands and Malone Friends' hands.
I would certainly prefer to have a break so we can discuss the point in a bit more detail. So I'll come back to you with a considered answer.
Okay, so you'd like to get a short break now and then come back then? Yeah. Okay. So shall we start again at 11:15 then? Is that okay? Okay. Thanks, everyone. If that's okay for everyone. So, Mr. McKee, I'll hand over to you maybe first, and you can. I think there was NPF 4 policy 4C, and there was the related question of the landscape designation status of the national park. These are items that are off my agenda. So, if you need to show me documents, just give me some time to find them and get to the right part of them, please. Over to you.
Thank you, sir. Maybe I could start with the designation point first, because it's to do with obviously fundamentals and baselines. So, The National Park's view, and it believes it is one that is shared with Nature Scott, is that the National Park is a landscape designation and it is the equivalent of a National Scenic Area. It is acknowledged that both of these derive from separate and different legislation, but both of the legislation, if we deal with the national park, when a national park is being designated under Section 2, the ministers are doing so due to the high quality of the natural environment within the park, and similarly with regard to national scenic areas, similar considerations are being looked at. So it's to do with the national importance of it and its high quality, its special qualities. So these are the same, and I think what manifests that most, sir, is National Planning Framework 4, where we see in Policy 4C national parks and national scenic areas and other national areas grouped together for the purposes of the sort of the two policy tests, 1 and 2. It'd be helpful for you to look at that, sir.
Okay, yep, so I've got that there.
So we have that as a recent manifest and an acknowledgement in the latest development plan, national development plan, shall we call it, that shows that. One of the documents which the appellants lodged on Thursday, which was a draft advice note from Scottish Natural Heritage, I think it remains in draft, but it has been obviously been looked at and considered in some detail in the Glen Sherrow Wind Farm report. But I think it's saying the same thing, sir. It is saying that they're both of outstanding importance in landscape terms, and they're considered together. There's obviously a slightly different aspect to the sort of issues of integrity in terms of national parks, but I think for the most part they are to be treated the same, and there's no particular sort of overall policy difference in approach. There are some elements which require more detailed consideration. I'll maybe just pause there, sir, because my friend may have a comment to make on that, obviously.
Okay, Mr. Finlay, is there?
My broad comment is that whilst the national parks and NSAs have similarities, to say they're the equivalent of one to the other is going too far. But I'll pass over to. I'm not sure there's a real issue. I mean, one is concerned with outstanding scenic value. The national park is concerned with other factors which Mr. Bell will deal with. But clearly, it's the same test in 4C. But I'll pass over to Mr. Bell to deal with that.
Thank you. Sir, just probably best if I frame it around your question. That might be most helpful. Your first point was, is the correct test to consider the effects of the park as a whole, and so on. And I would agree that the correct test is NPF 4 Policy C, Policy 4C, which is, we're all quite familiar with that. It was the same as paragraph 212 in the revoked SPP. There hasn't been a change, which is helpful when we look at other decisions in terms of how that has been handled. The test has two limbs. I think if there's a failure against integrity in the first limb, then that would be it. You wouldn't need to go on to the second limb because a development would be refused. But in terms of the necessity to look at the second limb, that brings in the qualities of the area, and there's a balancing mechanism. But if there are no significant adverse effects on why the area has been designated and special qualities, then there would be nothing to outweigh in that particular test. In terms of the point about whether the national park is a landscape designation, I think in most landscape and visual assessments, in my experience, it is treated as such. It goes in there in the mix. But I think the SNH guidance document, which, although it is draft, has been used in other inquiries. Most recently in Argyll, I think in the Narrachan inquiry, which had a focus on the Arran NSA from a development on the Kintyre Peninsula. But the note tells us in terms of paragraph 4 that NSAs are related to outstanding scenic value. And paragraph 10 refers to the park's specific landscape interests, but it's also clear that from paragraph 2 that a park isn't just designated for landscape interests, it's natural heritage or natural and cultural heritage as well. And I think the document that the Park Authority lodged this morning is actually quite helpful. I think, if I've got it correct, it was 1.37, which is the 2005.
137, I think.
Sorry.
Is that 137? It was the document lodged this morning.
Yes.
It wouldn't be 1.3.
Sorry, 137. Yeah, my apologies. So
what's its? I haven't put numbers on them yet. So what's its name? Of those
2005 policy document from SNH. That's not the exact name. Park Authority.
Oh yes, the landscape SNH's landscape policy framework 0501. That's the that's that we're talking about.
Yeah. So page 11, the second bullet says that national parks encompass landscapes whose sensitivity and associated values will vary across its area. And page 17, under the subheading B4 national parks, it says the parks area as a whole is of national importance for their natural and or cultural heritage interest, but the values attached to their landscape will vary across the parks, in part demonstrated by the presence of other designations. So, as with the Loch Lomond and the Trossachs National Parks, with the Cairngorms National Parks, you of course have the NSAs within the park that signify the greatest scenic value. So I would say from a practical planning perspective, where you have an NSA coverage, that is signifying that greatest scenic value. And I know from experience of looking at other developments in national parks, such as the Bewley-Denny overhead line, it was evident that the park's boundaries were formed for administrative reasons in part, not simply because it was all of outstanding scenic value, that there was different landscape units that contributed in different ways to scenic value. So I think it's important to recognise that there is that variation. So to say that NSAs are the equivalent of national parks, I think in a broad sense, in terms of a national level designation, I wouldn't disagree, but it's necessary to look into that in more detail with regard to any specific development that may or not affect an NSA or a national park. Yep. And
I was just going to. I'll come back. I was going to ask Mr. Bell a question, and maybe he was about to go on to it. But how does that play into an assessment under Policy 4C then? That difference, to the extent that you tell me there is a difference.
So I think it would be more in relation to the landscape evidence that you've got to hear about the particular effects of the development in a case. That's where it would come in. So are there effects on an NSA, or are there effects on special qualities? And that will be covered by Mr. Flannery. And I think just to finish on the point that the appellant has lodged the Glen Sherrow wind farm case. I was involved in that, so I'm quite familiar with it. And I think that could be of some practical assistance about applying the policy. Now, that related to a development that was outside the park boundary. It was 39 wind turbines at 135 metres to tip, 1.2 kilometres from the park boundary. And there's really just 3 paragraphs I think would be helpful to refer you to. 3.89, where the reporter said that no party was arguing that any level of significant adverse impact on special qualities would automatically mean that the unity of the park would be compromised. And he went on to say that the Park Authority is clear that the nature and significance of effects that are key to judging questions of impact on the integrity of the park. So that's my point about the landscape evidence that you've got to hear. So it's the nature and significance of effects. That's what's important to make a judgment on. Now, in that case, the reporter, paragraph 3.93, said that he considered the judgments on whether integrity was compromised was finally balanced. And he then said, I cannot advise ministers that it is clear-cut. And again at paragraph 3.94, he says, as I've mentioned, this matter is not clear-cut, and it may be that ministers do not agree with my conclusions based on the nature and scale of effect. So that was a scheme of that scale and nature, 39 turbines at 135, and the reporter was saying it's not clear-cut whether the integrity of the park would be compromised. So I think in a practical way, looking at the appeal before this inquiry, in terms of the nature of the development and the localised impacts that it would have, and this is set out in Mr Flannery's evidence, that underpins the appellant's position that the integrity would not be compromised, and that there would not be effects on the special qualities. So I think in terms of calibrating how that test is applied, I think looking at that particular example is quite helpful in terms of looking at the scale and nature of development and how it is the same policy as it was then in SPP is applied today through NPF4.
Can I add to that? It's also hopefully helpful for the Glen Sherry wind farm didn't affect the whole park. And it was an assessment. What you've seen there is a report around the ministers working through an assessment of how something that only affects part of it, how you then apply that against the test in what is now MPF policy 4C. So just because it doesn't affect the whole park doesn't mean you cannot have an effect on integrity. But it's helpful to, in answer to your, although we may have misunderstood it in part, the question you raised, you look at the areas upon which it has an effect, but then look how they impact on the whole of the park.
Yeah, I think the last thing I would add is in the Nature Scott guidance note, that's the appellant's document, paragraph 11 makes it clear that a significant effect on a special landscape quality or qualities does not inevitably compromise the designation's objectives and or integrity. So I think Nature Scott has been quite practical and measured about that you could have significant effects on a number of special qualities, but it doesn't lead to an inevitability of compromising integrity.
Okay, thank you. And before I pass over to the National Park Authority, as far as I understand, Glen Sherry it was out with the park, but the policy 4C doesn't just apply to developments within the national parks, developments which affect them, so it was still applicable. But yeah.
Common position between us and the Park Authority. I think they make it clear that developments in and outside the park can still engage that policy and to the same extent.
Thank you, sir. I mean, it's always difficult comparing, an entirely different development, and those on the other side of the room have an advantage having been involved in this particular wind farm. But I think it's fair to say that in this case, the reporter may have said that the impacts would compromise the overall integrity, and perhaps on a different day he may have said something different. But that is the conclusion he reached. And that was a conclusion that was also reached by the ministers in their decision to uphold his recommendation and to refuse it on the basis that a development of a wind farm 1.2 kilometres from the Cairngorm National Park boundary, although it was out with the park and it was impacting part of the park, it could nevertheless compromise the overall integrity. And to some extent, that is the National Park's case here, sir, that an impact, although it is not across the entire park, it's across the seascape, it's very significant as far as the park's concerned, and that's why it is of the view that policy for one is engaged. If I could maybe just turn to the policy test itself, sir, where and you were quite right to say that from a point of view of, even though these designations, a national scenic area and a national park area, they come from different legislation, for development management considerations, they are treated the same. And I think that's the real test. It doesn't matter, there's subtle differences between how they emerge. They are nevertheless of national importance. So they're treated the same. And I think you made that point. So in terms of what are the objectives of the... No, it would have smashed much more loudly from over there, so I can show you. So, sir, in terms of looking at the test itself, this is test 1, the objectives of the designation and the overall integrity. There's 2 elements to that, sir, so that's quite important. And the 2 elements are dealt with in the draft SNH note that was lodged on Thursday. At paragraph 10, sir, and it says, for the National Park, the objectives of a designation are further explained in the National Park Plan in terms of the vision, the set of outcomes, which should be read having regard to the National Park's 4 statutory aims. So in looking at the objectives of the designation, one has to look at the aims. And as you'll recall, sir, the decision notice refusing this proposal specifically references the Sanford Principle, and that this breaches Aim 1, which is the conservation of the natural and cultural heritage of the park. It then must impact on the overall integrity, and the overall integrity is described in the notes, sir. And the definition, it means the wholeness of the area, the unity or soundness of the whole being unimpaired, recognising that the entire area of the designation is valued. And this is the important part. And adverse effects to part of it could be damage to the unity or soundness of the whole. So small effects on one part of the park, and we are, in this camp, sir, saying that this is an important, very important gateway to the park. It's probably one of the only marine areas on the edge of the national park, let's be clear. So that's why, and I'm slightly deferring to Mr. Harman's evidence, where he is referring, and it will be tomorrow in his hearing statements he's prepared, that certain important special landscape qualities are compromised. And it's that compromising effect that leads the park to the conclusion that the proposal will compromise the objectives of the designation and the overall integrity. And in this regard, sir, I think the park would actually like to run an ESTO argument, because if you're not with the park in that regard, sir, then test 2 is engaged. It's a kind of 2-part test. If it fails one, then the development must be refused. But in test 2, that then describes that if you get past test 1, any significant adverse effects on the qualities for which the area has been designated are clearly outweighed. And the National Parks view, if you're not with us or ministers are not with us in terms of test one, is that there are very significant adverse effects. And once one establishes that those effects are happening, then that becomes a very high bar that I agree is capable of being surmounted, provided there are overriding or high environmental or economic benefits of national importance. But for this particular proposal, it's the Park's view is that whilst there are, there is a movement towards technological innovation, there are only potential benefits here. So the actual economic benefits themselves, 12 jobs, are not a lot. There's certainly the potential for sectorial improvement, but the Park remains to be convinced about that, and that is what I think we're going to be discussing in the nature of this development. And it embeds the real importance of you reaching a view on whether this technology is commercially proven. And I don't mean this technology, across all of the technologies for semi-closed. I mean this technology for this specific proposal, sir. I may just hand over to Mr. Beinn, sir, who will no doubt have further views. He is the Director of Place, but that's my understanding of the Park Authority's case.
Ms McKee's well covered the kind of policy points there. I suppose there's a few points from Mr. Bell had made, just a bit about the kind of designation and so forth that and geography I just wanted to kind of pick up on. I suppose on the kind of, I think, policy C is clear. National parks are listed alongside national scenic areas. I guess, our view is that, national parks are, landscape designations. Yes, they're designated in a way which included broader interest, broader heritage and qualities. But landscape is one of those. And obviously NSCs predate national parks. National parks were designated after national scenic areas. So certainly on a operational, on a practical level, from a planning function point of view, landscape is one of the kind of key considerations in any case. It is obviously within our overarching policies in terms of landscape being one of the kind of key kind of policy assessment points. So I think I just want to be clear, certainly our position is that national parks are very much landscape designations while covering other areas of heritage, culture, etc. And on the kind of boundary point, I think, it was actually, through work to establish the reasons for the areas included within the national park. That was obviously, it's not just administrative. It was down to assessment of, special qualities of, covering a range of areas. So it wasn't just, kind of administrative. And obviously there's reference to kind of guidance from Nature Scot and Scottish Natural Heritage. And I suppose it's important to point out that, obviously the Park Authority has its own landscape advisors. We have an arrangement with the Nature Scot where it is, the authority leads on landscape advice within the Park Authority area. So where there's guidance and other casework, sure it's relevant, but obviously we have our own expertise here, and we'll be hearing from our landscape architect tomorrow. On the point of the policy test here and integrity, just amplified, I guess, the point that Mr. McKee has made that there's particular qualities about Loch Long, about the area where the development is, which do make it, does make the location unique in terms of marine element. The national park area covers a large area with a variety of landscapes and natural features. But it was clear within our, within the reasons for refusal in the board report, where it was stated, the development would adversely impact the special landscape qualities for which the national park has been designated. So just wanted to make those points to add and come back on Mr. Bell's. Thanks.
Thank you. So actually, I'm just, not that it wasn't all helpful, but the point you make about the are landscape designations, but there are also designations for other things, kind of probably helps that. Is this my question about, is this a landscape designation? It's probably yes, but, or yes and. So, for example, if you were applying for policy 4C, you wouldn't, let's say there was an effect on visitor access or something to a site, you wouldn't necessarily, that wouldn't necessarily be relevant for the test a testing of effects of a national scenic area if it didn't affect scenic quality, whereas it might be irrelevant for the testing the effects in the national park, because those are, whilst landscape's one of its aims, there are those wider aims. So is that, and again, that's a hypothetical, but I'm just trying to, does it, the national scenic areas, it's scenic quality, which is the test, whereas in the national park, landscape's important, but so are other things. Is that what you're saying to me?
Yeah, I'm saying it's and landscape and yes, that's right. And if you look at kind of on the kind of policy intent here, I think that's when your point about if it's another type of development. Well, the policy intent is protect, restore, enhance natural assets, make best use of nature-based solutions. So it's quite broad in what it's saying. So it depends on the development type. But I would agree with your comments. Okay,
I mean that's fine. And I go back to the reason for asking was about methodology of landscape and visual impact assessments. We can get into that aspect of it tomorrow. I don't know from the appellant's side if there's anything you want to come back on. You don't necessarily need to rerun those policy arguments about the second limb of 4C, because I think I understand where people are coming from that. But is there anything just been raised there that you feel you need to come back on?
Yes, I understand Mr. McKee's estate case, but I also understand and take on board the point you made earlier that the decision's a matter for you and ultimately for ministers in due course. But the first reason for refusal, which I had understood, was to deal with this point of landscape and visual impact relates to the concluding sentence is that the development would adversely impact the special landscape qualities. I don't think there's a suggestion that the overall integrity would be compromised. I understand the way the park now puts its case, and we can deal with that in closing submissions. But you will have heard our submissions on the application of it. But in our submission, we don't get to integrity, and nor is there a significant adverse effect on qualities. Reference was made to uniqueness of this location and the novel technology, but those are matters for other sessions.
Okay, thanks. Does that cover all those things that we were to come back on after the break, or is there still anything outstanding?
We have nothing else outstanding. Thank you very much, sir.
Sir, I just have one point. It was just to clarify that my friend had asked what was the source of one of the documents I'd lodged this morning, of which it was an excerpt. It's an excerpt from the 2006 Special Landscape Qualities work by, I think it's by Scottish Natural Heritage.
Which document was that?
That was the I think it was to do with the Argyll Forest Park, I think, sir. Go to the one, I think it's got a picture of a tree on the first, it might be Beinn or something, I think.
Yeah, the PDF, it says CH2_SQ, is that?
That's it, that's correct, sir, yeah.
Okay, thank you. Okay, if that's everything then, I'll say thank you again for everyone for all your input. It's 11:45, so we can start the second hearing session at 1 o'clock as planned. We'll rearrange the room. I may need to move some of these tables slightly, but I think we're going to need to close off. I think there's so many people that we're going to have to go right round. I think it's fine. I think we can move them like that, and we'll be careful. Okay, thank you, everyone.